There are a number of legal issues that you will face when establishing a business, but 4 of the core areas, oops, have I got it on? There we go. 4 of the core areas are business structuring, relationships within your business organisation, protection of your intellectual property, and relationships with third parties, and this is either your suppliers or your customers. So when you structure a business, the things that you're going to be looking at are what's going to affect profit, and that might involve tax rates that you'll be looking at, and levels of risk, such as trying to limit your liability. Now, potential structures for a business include sole traders, partnerships and limited partnerships, joint ventures, whether that be incorporated or unincorporated, investment trusts and companies. Now, companies will be the one that you're most familiar with, and that's the one that generally business is done with in New Zealand. But there's positives and negatives for each of these structures. So the simplest operation would be as a sole trader. However, that's got no limited liability and it might not have the best tax rate for you. Limited partnerships, these are relatively common internationally, but it's quite a new concept for New Zealand. So part of the issue with those is getting your advisors feeling quite comfortable with them as well. But companies, these offer a comparatively lower tax rate, but there is a bit more complexity in their operation, but it is the one that most people are tending to use. So that's what we'll be talking about. So companies are governed by the Companies Act 93. They're made up of at least one director and one shareholder. The directors look after the operation of the business, while the shareholders essentially share in the proceeds from the company. Attention needs to be paid to how you structure your shareholding, because there are ways that you can do it, such as having a family trust, having your trustees of your trust hold the shares, and that way the dividends flow directly through to your family trust rather than to you personally. So really at the outset you need to be clear that the structure that you've chosen is the best one, because changing it later on can cause some issues, particularly in the tax area where it could be seen as tax avoidance if that's the main motivation for you changing your structure. Company has limited liability, which means that the liability essentially just attaches to the company, doesn't flow through to the members that make up the company, although you'll all have heard of various media reports where directors do face personal liability, and the times when that's going to happen are where the directors haven't fulfilled their director duties. Often with startup companies, funds are going to be a bit of an issue. You might need to get some funding into your company. There's different ways that you can do this. One way is to issue new shares in the company, and that's going to build the equity in your company. And another way to do it is to essentially get some investments and borrow some funds from your company, but that's going to increase your debt levels. So depending on what way you do it, it's going to affect your company's balance sheet. When you are just in a business on your own, so long as you stay within the confines of the law, then generally you can do what you like. However, once you start getting people involved in your business, then things do get a little more complicated. If you require assistance to do the work, you might decide to get some employees or contractors into your business, but different rules are going to apply to each. Now, the treatment of employees is governed by the Employment Relations Act 2000. This is employee friendly. It includes certain rules to be followed by the employer, such as entitlements to breaks, sick leave, termination requirements, personal grievance procedures, requirements to pay PAYE to IRD. So all of these issues will be addressed in your employment agreements. If, however, you look at going into a contractor relationship, this isn't governed by statute. This is a contractual relationship that you come up with. And essentially you can agree whatever terms you like for that. There are no statutory obligations to provide contractors with benefits such as sick leave or holidays, but whilst from an employer's perspective, and particularly when you're in your startup mode, it might seem like a more favourable way to go for contractors, you've got to be careful that if in substance it appears that the relationship actually is one of employer-employee rather than contractor, then regardless of what your contract says about that, your relationship will be deemed to be employer-employee, and those obligations, statutory obligations that apply to employers will apply to that relationship. So features of a contractor, really, just to help you know what really is a contractor relationship, is that they'll use their own equipment and materials. They have autonomy to decide how and when to get the job done. The appointment might be for a temporary period, although that one's not definitive, certainly not on its own, because you can have short-term employment agreements. That there's a written agreement that shows the intention, and that the contractor themselves make payments to IRD. So they're just potential ways that there are indicators that that's going to be a contractor relationship. Now, if there are multiple parties entering into business together, you'll want to place some rules around how that's to happen. And this is done by the adoption of a constitution and sometimes entry into a shareholders' agreement. Now, companies governed by the Companies Act, as we've said, certain provisions of the Act can be changed by constitution. These are a matter of public record and they're going to be uploaded on the Companies Office website. And one of the main pressing reasons for adopting a constitution is to have preemptive rights. Now, what that means is that under the Act, there is no restriction on shareholders selling their shares or offering their shares for sale to anyone they like. But what a constitution would do if you have a preemptive right provision in it is to essentially require those shareholders wishing to exit to first offer their shares to existing shareholders first. And that'll be the reason that a lot of people do adopt a constitution. Now, on the other hand, a shareholders' agreement is a private arrangement between the shareholders. Now, the only way to change the provisions of the Companies Act is via constitution, so a shareholders' agreement can't do that. So often these documents will work in tandem together. Now, a typical shareholders' agreement might include some operational kind of aspects. And what that will be is a right for the shareholders with a certain percentage of shares to appoint and remove directors, setting a dividend policy, statements regarding the purpose of the business so that everyone's clear where it's going, certain decisions that might require unanimous consent, such as expenditure over a certain value, and insurance requirements of a business, things that might be important are key person insurance. So, for example, a person is key to the operation of the business and they die, you'll want to have some insurance set up so that you can manage that period of looking for somebody else to fulfil that particular role. You might also want insurance to enable you to buy out the shares of that person. So often what you will find when discussing a shareholders' agreement is that the very process of actually discussing it is the catalyst for identifying potential issues that you might face. So it can be a really good development tool at the outset anyway. Now, once you've decided on your structure and you've got your internal management sorted, then you want to give due consideration at the outset to your intellectual property. Now, Jonas will be talking to you about this, so I'll only briefly mention it here. But there can be some significant value in intellectual property, and this is both during the operation of your business in relation to various competitors that you might have, as well as for the purposes of succession planning upon the eventual sale of your business. You can really show some value if you can hold up your trademark certificates and sell those over as part of your sale. Now, intellectual property is an important part of the business that, in the inevitable tension of a startup between limited resources and trying to choose what sort of things you need to get done, intellectual property can be overlooked or passed over in favour of other perceived more important areas. And we just caution this approach and that due consideration is given to the protection or appropriate protection of that intellectual property. And the last facet is relationships with your suppliers and customers. So these relationships generally are contract-based, and what contracts you might need to have in place will depend entirely upon the type of business that you're running. It might be things such as distribution agreements, franchise agreements and licenses, supply agreements. In the IT world, there's a whole range that are specific to it, such as service level agreements, software licenses, maintenance agreements, all that kind of thing. So entirely is going to depend on what realm you're in. But some sort of core examples are if your bank needs some financial assistance from the bank, such as an overdraft facility or some more working capital, that's going to involve them potentially taking a general security agreement over the assets of your business, which is what we'd expect them to take. For startups, it can be a little difficult to have that as your only security, and often what they will want is a director personal guarantee. Clearly that's pretty undesirable because it does put the director in with some potential personal liability, but it's a bit of a commercial reality if you want that funding. The next one is your terms of trade. So if you're supplying goods or services, you need to develop some terms of trade that clearly set out your expectations for that relationship. Now, one thing that's quite important in relation to terms of trade is particularly if you're providing goods on credit, and this is just if you've provided goods and you're invoicing on the 20th of the month, so that's enough to be called goods on credit. Now, the way that traders dealt with this was to include retention of title, or what was known as remalpa clauses in their terms of trade, and what the purpose of this was for was essentially to say that we retain ownership of those goods until such time as they're fully paid for. Now, clauses like that don't work on their own anymore. What you need to do is you need to have a registration on the Personal Property Securities Register. Now, what that is an online register, essentially, of security interests. So, if there is no registration on that register, then your rights to the goods that you've supplied on credit are relegated to the status of an unsecured creditor. So anyone with a registration on the PPSR whose rights potentially will include the goods that you've provided, such as a general security agreement that the bank might have taken over that customer's assets, they're going to have a prior right to those goods in satisfaction of their debt. So you may not be able to claw them back. So when you're deciding whether or not to register on the PPSR, depending on what you're doing, you might have a number of transactions that you're doing on credit. So the sort of things that, and it might just be unwieldy really to register every transaction. So what you might do is look at the level of value in the goods that you're supplying. If you've got a high value that you're supplying, yes, get that one registered. If it's only a small value, then you might take the risk with those ones. So in order to ensure that your security is effective, you need to make sure that there is a written agreement between the parties and that that agreement does give you a right to register a security interest. And secondly, you need to register that financing statement on the PPSR within the timeframe specified in the Act. Now, in summary, hopefully that's given you a bit of a brief snapshot of the various legal issues that you can face when setting up a business. And whilst the operation of your business will inevitably evolve over the course of time, it's worth putting some effort into making sure that at the outset it's as robust as it can be. What we've done is I've just bought some pamphlets which are called Your Business in the Law, which have a lot of what I've talked about in them, as well as some other areas of law that could potentially impact on your business, and I've just put them on the table out there, so if anybody wants to pick one of those up, then you're more than welcome. And my business card's there if there's any other information that you're interested in. But yeah, hopefully that's been a little bit helpful.